Board of Ethics meeting to order at 5:32. Let's stand for the pledge of allegiance.
Allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yes, I could swing it. The mayor would like to announce, I'm sorry, the chairperson would like to announce and have placed in the minutes that adequate notice of this meeting has been provided in accordance with the Open Public Meetings Act by publication in the
Home News and the Star Ledger. The Home News
Home News
and the Star Ledger.
and the Star Ledger, and by posting on the public bulletin board and filing the same with the city clerk and maybe on the website too, I'm not sure. But, so it appears that we have complied with the requirements of law for that.
To roll call, Clarabelle Escona Barber,
Here.
Reverend Lauren Carrington here, Anthony Jones is absent, Donna Pinkovich, Brother Jude Asota,
Here.
and Reverend Francis Burrell. Everyone is here. We'll begin with with old business, and the first is the complaint filed by Charles Craddock against Andrea Ito White.
All right, there's Ms. Ito White here. Why don't you come on up and sit at the table here? Get a chair for Ms. Ito White. That looks fine. Thank you for being here. I guess where we left off at the last meeting was the board made a determination to allow Ms. Ito White, I believe it was 30 days to cure the defects that were in her financial disclosure statements. So I guess that's where we are at this point. Can you relate to the board your efforts to straighten out those financial disclosure statements?
Yes. With the 2015 financial disclosure, as I previously stated, I wasn't part of the submittal of all of the actual commissions. I worked along with the state, and the last result was that a young lady, Dana, they found out that their software does not allow them to go into a man in order to do an additional person on. So they sent communicated everything to Dan Teresi. So between the three of us, we got a manual paper statement. So I submitted a manual to the state. Dan Teresi mailed it off, FedEx it off to Dana's attention. So that was done manual. And, I believe a copy of it was sent over to the ethics board by Dan Teresi, but I have a copy also.
Is that the letter from Mr. Teresi dated August the 28th, 2017?
Correct.
It says, "Dear board members, enclosed is a copy of Ms. Ito White's disclosure statement filed with my office on August 24th, 2017.
Right.
Right. And that was for the year 2015.
Correct.
And that was the year that you joined the, what's it called, board or
Department Authority Board of Commissioners.
Board of Commissioners. So you did not realize at the time that you had to file for that year because it was after,
Right,
it
it
was
was
after May 1st when you joined.
Right,
You didn't realize that you still had to file for that year.
yes,
So this has cured that
right,
oversight.
right.
Perhaps we should have this go into the record
Yes.
and I'll call that, and what were we with the other ones, was it? Yeah.
Yeah, you know,
Let's see how we marked. Was it R responder or something?
The letter 626 was all one issue.
Okay, so we'll mark that. R2 would be the letter from the city clerk acknowledging receipt of the 2015 financial disclosure statement. And was there also something that had to be done for 16?
Yes, for the 2016, I went in and amended the part of, that's when I went to training in Alabama. So I went in, that went under section C to list any source of gifts, reimbursements, or prepaid expenses. So I went in and amended that, so I also have a copy of that for the ethics board.
Could we have a copy of that, and we'll mark that also as part of the record? This is year of service 2016 for Andrea Ito White. And it lists under section C, gifts, reimbursements, or prepaid expenses having an aggregate value exceeding $400 from any single source, New Brunswick Housing Authority. So I'll make that R3. Okay. Takes care of it. You filed in 2017, there was no issue.
Yes, that was final.
So, it appears, if the board please, it appears that unless somebody has an issue that, as Ito White has complied with the board's requirements and cured the deficiencies in her previous filings. So, I'm not sure whether you have to do anything, but maybe you want to just take a vote to determine that she has discharged the obligation that you placed upon her.
So we'll do, I guess it's going to be a motion on the floor, or?
Motion on the
Let's
floor.
accept the motion to acknowledge that she has, that Andrea White has met all the requirements regarding her submissions
Correct.
as requested at our previous meeting. So we need a motion.
I'll make the motion.
Second. All in favor? of the motion?
Well, it should have a roll call vote.
Okay, I was accepting the motion, we will do a roll call vote.
Oh.
Is that?
Yeah.
So, Clarabelle,
Yes.
myself, yes. Nana,
Yes.
Brother Jude,
Yes.
and Brother Francis.
Yes.
So it's unanimous acceptance of corrective action.
Thank you, Ms. Ito White. And you're now discharged. Or at least on your own recovery.
And educated well, thank you very much.
You're going to be an expert in this field now.
So, if we want to go to the,
Thank you.
thank you.
Have a good evening.
Okay, you too.
All right, that takes care of that matter. item, I guess, the chair please, is the Leonard Beer matter.
So, we-
Yeah, we're,
Good evening.
Mr. Beer is present, and he is represented by Ms. Council, Ms. Burns. I believe you concluded the hearing on this matter at the last meeting. The only thing I did receive subsequently from Mr. Beer, and I apologize, I ran out the door without grabbing his letter, so I don't know if you happen to have an extra copy, Mr. Beer.
Yes, I do.
As a lawyer, it's always prepared. And this is the amended financial disclosure statements for Mr. Beer. There's one for 2017 that's dated May the 8th, 2017. That's when that was.
Yeah, that one was not a subject of Mr. Crabtrell's complaint, but what happened was, when I filed, I realized I had not had one investment that was in prior years, so I wanted to, so that was amended the exact same day I filed the original.
Okay.
Because after I printed it and read it, I realized it was one of the investment missing. The rest are the ones that Mr. Crabtrell filed the complaint related to.
Mhm.
All of those were completed in advance of the hearing date when I testified, and this is just the documentary evidence that in fact they're all fine.
And the 2016 amended report is dated March the 8th, 2017. The 2015 report is dated March 29th, 2017, and the 2014 amended report is dated March the 8th, 2017. So, I guess there's no reason why your letter needs to go into the.
It was just simply a transmittal indicating that the
Why don't
action
we
is fine.
collectively mark these as, I guess you'll have to check.
This will work.
Oh, there wasn't any? Okay, so we'll call this R1, I guess, collectively. 17, 16, 15, and 14 FDSs. All right, so just procedurally, I guess you're just reopening the hearing just for the purpose of admitting that.
right.
Is everybody agreeable to that? No objections? So, well, I'll consider that accepted by the board. Now, I think the appropriate thing at this point, I think the procedure calls for you to go into an executive session to discuss your decision in this matter. So, does somebody want to make a motion to go into executive session?
Second.
Second by Clary. And this one you go all in favor.
Aye.
Aye. Everybody says yes, no nay. Okay. We'll go into executive session. Ask me to read a proposed resolution, and then I'll have some discussion on the resolution, and then we'll vote on the resolution. Resolution 2017, I don't know if there's a number for the resolution, but that can be determined at a later date. In the matter of Leonard G. Beer, a complaint was filed with the Board of Ethics by Charles Prattville of New Brunswick on February 9th, 2017, alleging that Leonard T. Beer, General Legal Counsel for the New Brunswick Parking Authority, NBPA, Board of Commissioners violated financial disclosure requirements of the New Brunswick Code of Ethics and the Local Government Ethics Law, LGEL, by failing to disclose sources of income received by him in 2015. It should have been reported on his 2016 financial Disclosure Statement, FDS. On March 19, 2017, Charles Gradville filed an amended complaint with this board regarding Mr. Beer, which, in addition to the allegations contained in the previous complaint, alleges that while chairing NBPA's annual reorganization meeting on January 28, 2016, Mr. Beer took official action to benefit himself in violation of the LGPL and the New Brunswick Code of Ethics. I'm doing these are numbered paragraphs. Number 3 is the board adopted a resolution on April 24th, 2017, stating that the board had reviewed the complaint and amended the complaint and made a preliminary investigation in consideration of the matter, and that the board had determined that a reasonable doubt existed as to whether the above individual is in conflict with the city's code of ethics or any financial disclosure requirements. Number 4, Leonard T. Beer, through his attorney, James M. Burns, Esquire, filed a detailed response for the board dated June 26, 2017, responding to the allegations of the complaint and amended the complaint. Mr. Beer also testified under oath as to the facts contained in his response. The following is a summary of the allegations of the complaint and amended complaint of Mr. Gradville and the responses on behalf of Mr. Beer. A. Mr. Beer failed to list his state pension as a source of income on his financial disclosure statement, FDS, for the City of New Brunswick Parking Authority for the reporting years 2009 through 2015. Mr. Beer admits this allegation. He retired as a government employee in 2008 and receives a pension from the state of New Jersey. He states that he did not realize that pensions or retirement accounts were a reportable source of income to be listed on his FDS. After consultation with Trenton and referral to a 2015 local finance notice, Beer wrote a letter to the City of New Brunswick Ethics Board accepting responsibility for these omissions and stated that he would amend as many of the prior electronic filings as the system would allow. B. Mr. Beer failed to list the following additional sources of income on his 2015 FDS. 1. Official or office rental income, 144 Livingston Avenue, New Brunswick, New Jersey. 2. Rental income condominium, 7501 East Treasurers Drive, Union 5P, North Bay Village, Florida. 3. Interest income, Cheap Eats LLC, 1482 Main Street, Broadway, New Jersey. Typo. Broadway, Jersey. Number 4, interest income, Yellowbrook Properties LLC, 247 Bridge Avenue, Suite 5, New Jersey. Leonard Beer admits that the above sources of income were not initially disclosed on his 2015 FDS form. His explanations for omission of the above disclosures are basically various errors in understanding on his part. Subsequently, after review of a 2015 local finance notice and his own tax returns, Beer, with the help of an assistant, Sue Levine, was able to amend his 2015 FDS to reflect the 2014 income, including Beer's PERS pension and rental income. The amended 2015 FDS was entered into the system by Ms. Levine, but did not post to the state online reporting system. He was advised by the state that it is not possible for him to amend any FDS prior to 2015. He did disclose this information on his 2016 FDS. C. The March 19, 2017 amended complaint filed by Mr. Gradville contains the allegations of the first complaint, together with the additional allegation that Mr. Beer chaired the Brunswick Parking Authority's annual reorganization meeting for the entire meeting, including presiding over his own hiring as general counsel, and approval of the hiring of both Beer Associates and Timothy Haas and Associates as parking consultants for the NBPA. For several years, Timothy Haas and Associates has used and continues to use Mr. Beer's address of 144 Livingston as its official address for business purposes. Close plan. The essence of the allegations with regard to the reorganization meeting are that Mr. Beer chaired the meeting which he personally benefited from the outcome. In Mr. Beer's response to Mr. Cradville's allegations, he stated that all professionals selected by the MDPA are as a result of a fair and open RFQ process in which Mr. Beer plays no role, and by acting as chair during the 2016 reorganization meeting, he was simply calling the reorganization agenda as the secretary of any board can do. Number 5, the board notes that under Robert's Rules of Order, at an organizational meeting, the chairman pro tem presides over the nomination and election of the permanent officers. After the election is completed, the chair declares the results. This is a quote. After the election is completed, the chair declares the results. Unless a proviso attached to the bylaws prescribes otherwise, the newly elected officers immediately replace the temporary ones. And there's a site there, RORN 11th edition.
What does this say?
This is all caps, RONR, sorry. And 11th edition, close brand, page 560, Roman numeral 2, 21-24.
124?
21-24. Thus, unless there was a specific proviso to the contrary in the bylaws of the NBPA board, Mr. Beer, as temporary chairman, should have immediately turned over the gavel to the newly elected chairman to preside over the balance of the reorganization meeting. This would have eliminated the possibility of a conflict on the part of Mr. Beer with respect to his appointment as board attorney and parking consultant. The local government ethics law, NJSA 48:9-22.5, as well as the City of New Brunswick Ethics Code provide no local government officer or employee shall act in his official capacity in any matter in which he, a member of his immediate family, or a business organization in which he has an interest, has a direct or indirect financial or personal involvement that might be reasonably expected to impair his objectivity or independence of judgment. 7, it is not simply the existence of the conflict that may be cause to overturn the action of a public official, but also the appearance of a conflict. Randolph versus City of 315, Planning Board, 405 MJ Super 215, 226, Berlin Active, 2009, close brand. Disqualification is appropriate even if only the appearance of a conflict exists. Van Italy, ITALLIE, Franklin Lakes, 28 MJ 258, 226-27, 1958. 3, the board acknowledges that the requirements of the financial disclosure law can sometimes be confusing, especially for a local government officer who has numerous investments and properties. The board also acknowledges that Mr. Beer has been truthful and forthcoming in candidly acknowledging the deficiencies in his 2014, 2015, and 2016 financial disclosure statements. It appears that Mr. Beer made good faith efforts to obtain advice and clarifications from the Attorney General's Office and the local finance board and to correct these deficiencies. It appears that the 2014 FDS cannot be amended. I guess that's not correct. It was amended, cannot be amended online.
When the original, what happened, if you recall from the testimony, what happened was, at the time, like 214 was not amendable. By the time Mr. Cradville filed his formal complaint, they had changed the state system to go back an additional year. So
Okay.
once that was done, I could do it. But at the time that I amended my filings, 214 was not amendable.
So it appears that the 2014 FDS was not initially amendable, and he experienced technical difficulties in attempting to amend his 2015 and 2016 statements caused by, quote, glitches, unquote, with the state software. Ultimately, the statements were corrected. 9, although technically a violation, the board is not particularly concerned with Mr. Beer's failure to list his PERS pension, since this is already a matter of public record and unlikely to be a source of any conflict of interest. The other sources of income that were not listed by Mr. Beer could potentially be more germane, although there are no specific allegations with regard to same other than the failure to list them. The respondent essentially pleads ignorance with regard to the omission of these items. Nevertheless, the board feels that as an attorney and as the chief legal advisor of the NBPA, Mr. Beer should be held to a higher standard of adherence to the ethical rules and regulations. Number 10, with regard to Mr. Beer's presiding over the NBPA's reorganization meeting as, quote, temporary chairman, unquote, during which his professional appointment and his appointment of his consulting company and that of Timothy Haas and Associates were approved, the board finds no merit in the argument that this procedure has always been the, quote, unwritten policy, unquote, of the NBPA, and that the respondent played no part in the fair and open RFQ process and was simply following the reorganization agenda. And the board finds that the action of Mr. Beer as temporary chairman and presiding over his own appointments and that of his tenant, Mr. Haas, created the appearance of a conflict of interest to the benefit of himself and affiliated companies. The board feels that the NBPA's 2000 change in its policy of having the temporary chairman preside over the awarding of professional contracts is a tacit admission that the previous policy created the appearance of a conflict. Number 11, in view of the above violations found by this board, taking into consideration Mr. Beer's cooperation with the Board of Ethics, his acknowledgement of responsibility in the matter of his financial disclosure statements, his good faith efforts to correct his FTS in spite of bureaucratic obstacles, and the lack of any previous ethical violations by the respondent during his many years of important service to the city, a penalty of $200 is assessed against Leonard T. Beer, which I am to understand is allocated as 100 on account of the disclosure statements and 100 on account of the presiding over the meeting. So that is the resolution read. Now, first we would need to have someone move the resolution, and then there can be a discussion on the resolution.
Make a motion that we,
All right, I think the chairman should.
okay, that's
Unless you want to leave the chair, it would be, all right. Well,
I'll second.
second. Now we can have discussion. If anybody want to make any comments?
I mean, as we talked about, the amount was based on the understanding that, we know that this is not something that was intentional, but there should be some responsibility taken for the action. So we looked at $100 for the RTA. Right, I got the right letter, sequence. Right, and then also the $100 for the issue with the chairing your meeting.
I understand.
Deciding over.
I think you meant the FDS, the financial disclosure statements.
FTS is the floral people, right? So anybody else comments?
Frank, did you want to say something?
No, I can't. It's a violation, but it goes again to, was there any intent? People, if we did that as a regular thing year after year, that's just going to need to be corrected, that we don't do it again. We are holding you to a higher standard because of your background training.
I understand.
Does anybody else want to statements? All right. In that case, chairperson want to call a motion, and
We'll accept the motion to accept the resolution as.
well, I think we already did we make
No, we
already
made the motion. So we're calling the motion to be voted upon at this time. Do you want to call it, chairperson? person, or do you want me to call the roll?
Carabelle.
Yes.
Myself, yes. Lauren Carrington, yes. Donna Pickovich.
Yes.
Brother Jude. Yes. And Reverend Francis Brown.
Yes.
So it's unanimous. Acceptance of the resolution.
The rules of the board are a little, they say that you're supposed to notify the appointing of body of your decision. And if you recommend that any further action needs to be taken, is there any feeling on the board that any further action needs to be taken?
No.
No.
Okay.
Just submit that this action has been taken. You know, we've already made the fine, and that's sufficient as far as we feel.
Why don't we just put that on the record, somebody make a motion that feels that no further action needs to be taken? Elder Jude,
I said no.
second. All in favor?
All in favor? Aye.
And opposed? No. All right, so that appears to conclude the matter. I'm not sure who you
I'll call the
give
clerk.
your check to, but probably to the city clerk.
I'll call the city clerk, Dan Tracy, and find out to whom I have to make the check payable.
We don't take money.
No problem. I understand. No problem. I understand. Thank you.
Thank you.
Thank you very much, Mr. Chairman.
Remind me, Madam Chairperson, when we get back, there's a couple of items of new business that we may want to note for the record when we come back. As to Credible. I think the next item of business,
This complaint, the next item is complaint filed by Charles Catterall against Anthony Digby.
yes, and this is just a preliminary stage of this matter, even though it's been hanging out there for a while. As I understand the procedure, at this point, the board is to go into executive session again to discuss how and whether to proceed in this matter.
Yes.
So again, I guess we'll have to ask the audience to, which is reduced to one person, to excuse us. Does somebody want to make a motion to go into executive session? Somebody want to second that?
Can we have a 5-minute recess?
Sure.
To use the
Sure.
facilities?
No problem.
Everybody.
You didn't get that on there, did you?
I do. Is it going to just- No problem.
Can you check where is it?
We have a motion to go into executive. Normally you should call a roll call on that. Want me to do it?
Yes.
Clary?
Yes.
Brother Jude?
Yes.
Reverend Lauren?
Yes.
Donna?
Yes.
Reverend Francis?
Yes.
Okay. I'm going back into public session.
Make a motion, go back to public session.
Second.
All in favor?
Aye.
Okay.
Read the resolution.
Yeah, I mean, at this point, I just want to note for the record that the procedure is under section 2-32-100, I'm sorry, 2.32.100 of the township's code, city's code. Stop calling it a township, I'm coming from the country. Says the ethics board shall make a determination as to whether the complaint is within its jurisdiction or frivolous or without any reasonable factual basis. If the ethics board concludes that the complaint is outside of its jurisdiction, frivolous or without factual basis, it reduces that conclusion to writing and transmits a copy thereof to the complainant and to the officer or employee against whom the complaint is filed. Otherwise, the ethics board shall notify the officer or employee against whom the complaint is filed of the nature of the complaint and the facts and circumstances set forth therein. The officer or employee shall have the opportunity to present the ethics board with any statement or information concerning the complaint which he or she wishes. All right, so this is a proposed resolution of the board in the matter of Anthony Vanillo Esquire. Whereas the board received a complaint from Charles Gradville of New Brunswick alleging that Anthony Vignola, attorney for the Board of Ethics for the Special Counsel, the Board of Ethics of the City of New Brunswick violated the local government ethics law and the city's code of ethics in the following particular. 1. Failed to file a financial disclosure statement, FDS, for the year 2016. And whereas the board has reviewed the complaint and made a preliminary investigation and consideration of the matter, and now therefore be it resolved by the Board of Ethics of the City of New Brunswick that the board makes the following findings and conclusions with regard to the above matter. Number 1, a complaint was filed with the Board of Ethics by Charles Gradville on February 1, 2017 against Anthony Vanillo Esquire, the board's special counsel. In his complaint, Mr. Gradville alleges that Mr. Vanillo was appointed to serve as the board's attorney at its annual reorganization meeting on January 21, 2016. He further alleges that as such, Mr. Vanillo was required to file a financial disclosure statement, FDS, under the local government ethics law and the city's code of ethics. Despite having been required to file an FDS in his role as a board attorney prior to April 30, 2016, Mr. Vignola allegedly failed to file an FDS in 2016. Number 2, there does not seem to be any dispute that Mr. Vignola did not file an FDS in 2016. The board will assume for purposes of this resolution that the allegation by Mr. Gradville that Mr. Vignola did not file an FDS in 2016 is true. Thus, the issue is whether Mr. Vignola was required by law to do so. Number 3, the local government ethics law, NJSA 48:9-22.6, provides that local government officers shall annually file a financial disclosure statement on or before April 30th of each year. NJSA 48:9-22.3G defines local government officer, LGO, as a managerial, executive, or confidential employee of a local government agency. On March 16, 2016, the New Jersey Local Finance Board issued Local Finance Notice LFN 2016-07 regarding the obligation of local government officers, LGOs, to file 2016 financial disclosure statements under the local government ethics law. LFN 2016-07 states the concept that LGOs have personal responsibility for annually filing their FDS forms is an important one. Municipal clerks, county clerks, and other local government entity representatives who have administrative responsibilities concerning the FDS filing process are not required to complete FDS forms on behalf of LGOs, nor are they required to ensure that LGOs satisfy their statutory obligation to annually file an FDS. The failure of an LGO to comply with the annual filing requirement subjects the LGO personally to the penalties and disciplinary action provisions as set forth in NJSA 48:9-22.10 and 48:9-22.11. This means that each LGO has a personal duty by virtue of the LGO's public office appointment or employment to carefully read LFN 2017-08, which is issued in the coming weeks, understands the online filing procedure, and take necessary steps to timely file the LGO's FDS. Number 5, notwithstanding the above, the local finance notice describes in detail the role of municipal clerks and other government entity representatives in preparing and updating the, quote, LGO roster, unquote, of the particular local government entity. The notice prescribes that it is the LGO's representative's responsibility to ensure that the LGO roster is fully and accurately updated on or before April 1, 2016. The notice further stating, the LFB requests that each municipal clerk, county clerk, and other local government entity representative carefully review their LGO roster in consideration of the guidance provided in this section and in consultation with local counsel. That's Local Finance Notice 2016-07 at page 4. Number 6. LFN 2016-07 does provide specific guidance on some positions. For instance, the notice lists that independent local government agency attorneys are being required to file an FDS pursuant to AO 91-0134, and local ethics board members being required to file under AO 92-0061. The local finance notice does not specifically mention the position of local ethics board attorney as being either required or not required to file an FTS. Number 7. NJAC 5:35-2.1, which clarifies which individuals are required to file an FTS, was not adopted until January 31, 2017. Too late to give guidance for the year 2016. However, a review of Attorney General opinions with regard to the filing requirement, I just started paragraph 8. With regard to the filing requirements is dispositive. Attorney General Opinion 92-0061 provides that members of the local ethics board are local government officers pursuant to the local government ethics law and therefore subject to its terms, particularly the requirement of filing a financial disclosure statement. The opinion further states, the term local government agency encompasses a myriad of local government bodies. The definition is very broad and specifically excludes only purely advisory bodies and school boards. A local ethics board is a board established by a county or municipality, and it exercises considerable authority in the specialized area of ethics, which go beyond a purely advisory nature. Thus, a local ethics board established in accordance with the local government ethics law is a local government agency pursuant to the law. AG Opinion 92-0061 at page 2. Number 9, Attorney General Opinion 91-0134 advises that an attorney appointed to regularly provide advice and representation to an independent local government agency is a local government officer pursuant to the local government ethics law and therefore required to file a financial statement. However, AG 91-0134 emphasized that only the principal legal advisor, page 3, or the chief legal officer of a local government agency would be considered an LGO, as contrasted with an attorney who serves the agency in a special limited capacity, e.g. special labor bond counsel, or to handle a particular tort action. I think that should be special labor counsel, bond counsel, or to handle a particular tort action. The latter representation being more akin to an independent contractor who would not be subject to the ethics law. AG Opinion 91-0134 at page 4. Number 10. Therefore, an attorney appointed to provide regular legal advice to an independent entity, which is a local government agency, is a local government officer, LGO, for purposes of the local government ethics law, NJSA 48:9-22.1 and C, and is subject to the requirements of the law, and particularly to the requirement of filing a financial disclosure statement, FDS. Number 11. In accordance with all of the above, the threshold issue in the within matter is whether the respondent, Anthony Vignolo, meets the definition of a local government officer. In this regard, the The board's attorney has caused a search to be made of the resolutions of the New Brunswick City Council appointing Mr. Vignolo to represent the Board of Ethics with regard to various matters from 2014 to 2016. Number 12. Attached to this resolution are copies of resolutions R-111414 adopted November 5, 2014. R, these are capital R's, dash 031506 adopted March 4, 2015. Capital R dash 111509 adopted November 4, 2015. Capital R dash 021669 adopted February 17, 2016. Capital R dash 061630, comma, adopted June 1, 2016. Capital R dash 091661 adopted September 21, 2016, and capital R dash 121617 adopted on December 7, 2016. All of which refer to Mr. Vignolo as, quote, special counsel, unquote, regarding a specific complaint before the board. Nowhere in any of these resolutions is Mr. Vignolo referred to as the, quote, Board of Ethics attorney, unquote, quote, board attorney, unquote, or, quote, regular board attorney, unquote. In addition, it's number 13. In addition, the attached City Council Resolution R-031509, adopted March 4, 2015, appoints James F. Clarkin III, Esquire, as, quote, special counsel, unquote, to the Board of Ethics with regard to an ethics complaint filed against the Assistant City Attorney, Charlie Gaydon, G-A-Y-D-E-N, Esquire, and the Honorable Judge Barnett Hoffman, J.S.C., retired. Number 14, based upon the above, it seems clear that the City of New Brunswick did not consider Mr. Vignolo to be the, quote, regular, unquote, Board of Ethics attorney, but rather seems to have appointed Mr. Vignolo on an ad hoc basis with regard to specific matters coming before the Board of Ethics. The appointment of James Clarkin as another, quote, special counsel, unquote, would seem to buttress this conclusion. 15. Furthermore, the board notes that Mr. Vignolo was specifically not included on the city's official list of LGOs required to file an FDS for the year 2016. While the board understands that the fact that the city did not include Mr. Vignolo on its 2016 LGO roster is not necessarily dispositive of the issue, it is a clear indication of the city's understanding that the respondent was a, quote, special counsel, unquote, and not the, quote, regular, unquote, Board of Ethics attorney. Number 16, the New Jersey Register of March 6, 2016, in response to a question from Seaside Borough Administrator, the local, I think that should be the Seaside, I'll have to check that. Could be Seaside Park. Borough Administrator, the local finance board stated, quote, with respect to the positions of municipal attorney and municipal engineer, alternate, special, and conflict attorneys or engineers would not be required to file financial disclosure statements. The rule would only require a financial disclosure statement to be filed by the attorney and engineer who is appointed to represent the local government entity as its attorney or engineer, along with any attorneys or engineers in the same firm and those named appointments who regularly provide professional services to the local government entity. This rule remains consistent with interpretation set forth in the Attorney General Formal Opinion 91-002, paren 49 NJR, New Jersey Register 433. Conclusion. The reasons stated above, if the board finds and determines that Anthony Vignolo has a appointed by the city council to be special counsel to the Board of Ethics with regard to specific matters do not meet the definition of quote, local government officer, unquote, during the time period in question. Accordingly, the complaint filed against Anthony Mignolo on this matter is without a reasonable factual basis and is hereby ordered to be dismissed. The board is aware, this is not a new paragraph, the board is aware that of the fact that Mr. Mignolo's name was added to the city's LGO roster for the year 2017, and that Mr. Mignolo apparently filed a 2017 FDS in response thereto. The board makes no finding with regard to the propriety or necessity of listing Mr. Mignolo on the city's FDS roster for 2017, as that matter is not before the board. And it is further ordered that a copy of this resolution shall be transmitted to the complainant, Charles Gradville, and to the respondent, Anthony Mignolo, Esquire. All right, so there you have the resolution as read before you. Does anybody wish to first make a motion in this regard, and then we can have discussion on the motion, if there is any.
You accept the motion?
I make a motion to accept the resolution that you read.
Do we have a second? Second. Oh, I just want to note for the record, I should have done this earlier, that Brother Jude sort of kind of last minute realized that he might have a possible conflict, and to be on the safe side, he decided to recuse himself from this matter. And so he is not sitting here in judgment when he's watching from the audience. But he did not participate in the decision that is being made tonight, out of an abundance of caution. Okay.
It's been moved and second.
It's been moved and seconded. Is there any discussion on the motion?
Oh, second.
Father Francis?
Yes, sir.
Reverend Francis.
I don't have any further discussion.
Do you have any, anybody want to say anything? Okay. In that case, does somebody want to move the motion?
I move to vote on the motion.
Okay,
Seconded?
all right, so can we have a roll call vote?
Sure. Clarabelle,
Yes.
Donna,
Yes.
myself, Lauren, yes.
Francis?
Yes.
Brother Fred.
Okay, so it is a unanimous decision.
Yes.
So what I will do, there's a number of typos in this resolution. I will correct the typos and send out a corrected copy with the attachments to everybody,
Thank you.
including Mr. Crowder.
Thank you.
So do you want to copy this to?
Take a couple.
Well, it's with, let me correct, okay. If you want, Caroline, okay. All right. I think that finishes the old business before the board.
Yes.
The only, yeah, there is new business. I wanted to note that apparently Mr. Cradville has brought 2 new complaints with him. And Mr. Cradville, are you filing these at this time with the board?
Yes, sir.
Yes, he's nodding affirmatively. I'm not sure what the procedure is.
So the process is it goes to the,
Me file with the city clerk?
Yeah, I was just going to say, I think he probably has to go to the city clerk first, and then it comes to the board.
right.
So we can note for the record just that we seen the copies and are aware of them, but that they should really be filed with the city clerk first, and then they will come to the board in due course. So having noted that for the record, We did a business with it, right?
I just want to thank you. You know, I know you were a special conflict attorney, so our conflicts, I'm assuming, are done.
You
And
may
you
not
will
see
not
me
be-
again.
you will not be our attorney again unless appointed as a special counsel by the, who does it?
So
Counsel?
the department,
Whoever
I'm
appoints.
not sure I want to be, this is a dangerous town.
But I also want to say, thank you, because I think I've learned a lot, you know, from you being our special counsel.
Thank you.
And I thought you handled this very fairly, and so just thank you.
Thank you.
I concur.
Thank you very much, all board members. I'm going to miss you guys because
Thank you so much.
it's been very interesting.
You never know.
Yeah, well, yeah.
You've educated us all.
But I've learned a lot about New Brunswick and the New Brunswick board, so it's been very interesting.
Thank you, sir. Thank you for what we do.
If the chair, please, I think you have a couple other things on your agenda.
The next would just be open the floor to public comment.
Good evening, members of the board. Charles Pradville from New Brunswick. I'm the editor of New Brunswick Today. I'll just start by saying it would have been nice to get notice of this meeting. I was not notified of the meeting. I happened to see on the downstairs bulletin board that it was scheduled, but I do think that that was not done. Maybe I'll check my spam folder or something, but I received no notice of this meeting. I think that I should have. I think that before the board breaks up today, you must select a secretary. I think that's an issue that came up a couple meetings ago. Mr. Jost was on the money. He said, hey, some of the reasons that we're having these communication problems is because there's no secretary. So that's got to happen. I don't know who dropped the ball or how, but the board needs a secretary, and the board is also going to need an attorney. I've filed these 2 new complaints, and I think my opinion that Mr. Vignolo is unfit for serving as your attorney. I would also like an update on getting a presence on the website. Is there any presence that this board has on the internet?
Just discussion, I understand that we don't have, the district report does not have a specific presence, but there is the city's website, and that would be the place for any issues or concerns that regarding the ethics board can be. Since there is a city's website, I think that would be the place for that.
Right, and so as you know, websites can be changed and information can be added, and there is currently 0 information about this board on the website. So I'm not suggesting that you need, perhaps you're unclear about what I'm suggesting. I think that the city's website should include a space for the work of this board. There's a couple of things that are obviously should be a part of it, the code of ethics, so that people who are bound by it can look it up, and people who might be interested in holding people accountable can look it up. That's not available presently.
Okay, is that the concern of the board or the concern of the city? I don't know what you're saying. Is that something we should be looking at?
You could certainly collaborate with City Hall. They have a public information officer who probably could make it happen if somebody...
As a concerned citizen, what would you suggest?
I would get on the phone with Jennifer Bradshaw, the public information officer. The city does already have a website, and you could be a part of that. Alternatively, if you want to do it separately, like the Trenton Ethics Board has their own separate website, you could do it separately. It might be more work, but...
Who's that person you said?
Jennifer Bradshaw. She's with the mayor's office, the public information person.
Yeah, that probably wouldn't cost much. It would just be a matter of, working up a statement about what the board is and what it does, and having maybe some of its decisions, or at least some of the rules and regulations of the board and the local ethics law. That probably wouldn't cost much money, because the problem is always money. But as far as the board secretary, unfortunately, you don't have the financial capacity to appoint somebody, because you have to get approval of that from the city. I don't know whether, we did discuss it several meetings ago. I'm not sure if that request was transmitted to the city or to whom in the city, but you might want to reiterate, somebody might want to reiterate that, because I do think it's a good idea to have a secretary. Obviously, there's been some confusion in the past, and it would be helpful. Now, maybe someone who's already working in the city government could have that added to his or her portfolio, perhaps at some increase in compensation, or maybe just included in the compensation, depending on how it's arranged. There's ways to do that. But unfortunately, this board doesn't have the financial wherewithal to just go out and appoint somebody. It has to go through the city council.
Okay, so someone will follow up and
Yes.
pursue that. Thank you.
Both things.
Right, the website and the board. And so am I correct to understand that the board is not going to accept my complaint tonight? My two
But
complaints?
that's not the procedure. The procedure is that it should be filed with the clerk's office.
The board is noting that they have been made aware of your two complaints, but that they feel it should be filed with the city clerk.
Okay, I find it unusual, and I'm going to see the city clerk on Wednesday, so I'll just give it to him then. But
Charles, what did you do in the past?
I've sometimes given it to the clerk, but I've also sometimes presented it to your council, and he's accepted.
Okay.
So I believe it was Mr. Clarkin that I handed it to back in the summer of 2015, and he had no problem accepting it. And
And you know what?
I don't see why not.
We should have a procedure because, like everything else, like he was over he was chairing something that he shouldn't have been chairing. Let's get the proper procedure and find out what that is. So there's no question.
And I think after that, there was some clarification that the filing should have gone to the clerk, and so there could be, I think it's notarized and some other things that have to be done around that filing. So to keep things in decency and order, I recommend you just file with them and there's no issues.
He may have been assuming you were getting it in that just for informational purposes, but probably to keep it clear, it's probably better to follow the accepted procedure.
It goes to the point that it's unclear.
Right. Let's get clarification.
Yeah, sure, great, okay. And then, appreciated watching your work today, but I gotta say I was disappointed with some of the conclusions you reached with regard to the complaint against Mr. Vignolo. So, I just want to understand, is this ethics board saying that Mr. Vignolo is not their attorney, is not presently the ethics board attorney, and was not in 2016?
I don't believe that's what we were saying. I was saying, what we said is his title is special counsel, and as special counsel, he was not required to submit the FDS statements.
Right, so when you hired him to be the special counsel,
That was his appointment, yes.
according to what?
According to all the resolutions adopted by the city council.
City council, right, and so that's the first misunderstanding. The misunderstanding is that this board hires their attorney. And it's been, trust me, I've asked many times to get clarification. Who makes the call? I mean, even we heard a board member today being unclear about who makes the call as to who this board's attorney is. It's not the law department, it's not the council, it's not the mayor. It is the five of you and the sixth member who's absent. That is the body that picks their attorney. And indeed, the council has to approve the bills for the attorney. And the bills that the council has been approving related to Mr. Vignolo's work are all related to a singular case from 2014. And you guys, some of you are new, you might not remember, so if you indulge me, I'll just tell you what happened. And so I first met Mr. Vignolo in 2014, and it's important to note he would not be bound by the Code of Ethics at all if the Ethics Board had not hired him in the first place. This board hired him to deal with a matter in late 2014. I filed it in August of 2014, and then the hearings that he led were a farce. He abused his authority and without the knowledge of the board, issued an unconstitutional subpoena to try to force the New Brunswick Today newspaper to hand over its videos of that hearing because he had not made the proper arrangements for the board to record its own hearing. He wanted to force our newspaper to provide it under subpoena, and indeed a condition of that subpoena was that we wouldn't be allowed to release it at all to the public, and it would essentially tie our hands with that. Of course, it was unconstitutional. Of course, it was a violation of the First Amendment, and of course, he backed down, and eventually we did, release the video for all to see, but that was an embarrassment. And so after failing to do that, he got you guys to pass an erroneous resolution in that matter, and that created an opportunity for the case to be appealed. I took that opportunity, and it's still tied up to this day in the Office of Administrative Law. So all those bills that the City Council is voting on are all related, not to Mr. Vignolo's work in 2016, which is an issue in my complaint, but it was actually all related to this complaint filed in 2014, and yes, he was the special counsel. They brought him in especially to handle that matter, and then they brought in Mr. Clarkin to especially handle another matter.
Wasn't your complaint that he didn't file the proper paperwork, not whether or not he was the attorney for this board?
Well, your resolution that you just adopted tonight indicated that he was not the board's attorney, but he was hired on an ad hoc basis.
Never said it was not the board's attorney.
He said he was not the principal legal advisor or the chief legal advisor, right? So I'm contesting that. I don't think that was true, and I think that the board members who are here might remember what actually happened, and I know that there's videos that will show what actually happened, and that indeed he was, in 2016, crystal clear, he was the principal legal advisor or the chief legal officer of this board. There are videos that show him being hired as the regular attorney, not a special counsel for a special case. The proof is in the pudding, and it's actually, this board, some of you were there, and you hired him as your regular counsel. And indeed, the only way that he was not the counsel was when the complaint was against him and he had to step aside, and then a true special counsel is brought in, and I agree. Special counsel not required to file, regular counsel is required to file. And 2016, Mr. Vignolo was required to file, did not file, and I think your decision is based on a flawed premise, and I think it's that's made even more obvious by the fact that the board chose to make no finding at all with regard to Mr. Vignolo filing for 2017. If he's not the regular counsel for the board, why is he filing?
That's a whole different thing, and if you want to make a complaint about that...
I'm not going to complain that he filed.
That's a whole different thing.
What I'm saying, it exposes the flaw in your judgment here. That you're saying he's not the regular counsel, yet he filed in 2017 as the regular counsel. So it doesn't pass muster that in 2016 he wasn't the regular counsel without any proof.
We're getting into a debate over a case that's already been decided, so I understand where he's coming from, but now you made the decision, and that's the basis of it.
Okay, I think it might be worth revisiting your bylaws since you made the decision without giving me a chance to explain this stuff.
You just explain it.
But you've already made the decision, so now I'm sort of being says, too late. But I could have told you this stuff if you'd let me prior to the decision making, and I'm concerned that the board themselves is not clear on their own power to hire their attorney and to decide who is the regular counsel and who might be in another position. It is only this board. The city council, whatever resolutions they might pass related to payments or bills, that is not the deciding factor. You are actually in charge, and you will have a decision to make after these complaints are filed as to who your attorney is. And the most important decision you can make is to not hire someone who has skirted the law, violated the ethics laws, and actually abused their power in their position on this board. They've hurt the credibility of this board greatly, and they, out of the blue got hired to do the same work for Middlesex County Ethics Board, and they've really hurt their credibility too. So anyone but Mr. Vignolo would be my recommendation for who your counsel is, and I think you missed the chance to hold one of your own people accountable, and you should have held them to that standard as a local government officer, because your regular counsel is that, and he was your regular counsel in 2016. I hope he's not your counsel ever again, and thank you for giving me the time, and thank you for evaluating my complaints. Have a good evening.
Thank you, Sherry. I will take the motion for the secretary. Can you talk to his office to see about, a little bit about that happening?
Yeah,
You want to follow up on the website?
Sure.
Okay. Yes.
and I just want to say, I mean, it's sort of the same problem with the secretary as with the attorney.
Right.
The city apparently uses kind of a zero-based budgeting thing, so every time somebody's appointed, it has to go through the city council, and so you can't, yes, theoretically, you make the appointment, but in reality, who's got the power of the purse? And that's,
Well, who's hiring? Will it be us hiring the secretary then?
you would be appointing the secretary. Guess who's hiring her, guess who's paying for
No, I
him or
get that.
her, or whoever it is.
Yeah, that's why I asked you to
Yeah.
look into it. and see
So,
what's
but I think it's the point of, having a secretary is a point well taken, and I apologize if Mr. Cradwell wasn't notified. I thought I notified him. I'll have to go back and look through my emails and letters and so on, but if I didn't, I apologize, but I guess word got to you anyway. So I think we've probably beat this as much as we can tonight. So anyway, if I don't see you again, it's been a pleasure.
Well, it has been a pleasure, sir. Thank you. Thank you so much.
Do we need to set dates?
Yeah, we got the email came out, so, I have some dates that I'm available.
We want to just get 2 dates that people are available for our next, for another meeting.
Okay.
Okay. So if you could just give us the dates that you have, we can start with you.
I have October 9th, October 23rd, November 6th, November 20th, and December 4th.
These are one days?
What are those dates? Can you repeat?
I'm available on the 9th of, these are all Mondays.
The 9th is Columbus Day. Is that a holiday still in the United States of America?
I'm sure it is.
Oh, no, so far. Good question.
No, we close the,
23rd,
You closed?
Yes.
I didn't know it was still federal holiday.
Six.
Sure.
Yeah, no, it is.
the 20th of November, and the 4th of December.
Second.
You said the 11/6 and 11/20. 20, okay.
10/23, 11/6, and what else?
So we just need to,
12.
yeah, let's just go through,
October?
well, no, is everyone available on the 23rd?
I'm
Of
not.
October?
You're not?
I'm not.
Okay.
I'm the out of state.
Okay, I'm now on it.
Okay.
How about this November 6th?
November 6th.
Okay, so
I'm
let's
okay.
start with that.
Okay, November 6th.
Okay, and how about November 20th? I think that's Thanksgiving week. No, it's
November, what day? Huh?
or November, that's the week of Thanksgiving.
The 20th?
Yeah.
Okay.
Is that
I'm okay.
I'm okay.
Okay, all right, so we can give her 2 dates, so if we have another meeting.
Okay.
We just had to find out.
So hold those dates.
Anthony as well, right?
Yeah, so she asked us to get 2 dates so that we can check with Anthony, and hopefully he's available one of those dates.
So we say the 6th or the 20th.
Yeah, either 11/6 or 11/20. If we have, to schedule a future meeting.
Is this with regard to new complaints?
Yeah, I guess, since we know that we've had 2 filed, so. She just asked us to get 2 dates, so we'll schedule.
See if he gets appointed as special counsel for these matters. He may or may not.
Well, at least he has these 2 days to work with, to start.
Who's getting appointed to special counsel?
We're not
We
sure.
don't know.
Yeah, I'm just saying,
We won't know until,
Yeah.
we'll work that out when we know.
Thank you for the education too, and the history, some of us are new here, and I appreciate that.
So I think we had to beat everything which, okay, I will accept a motion to adjourn this meeting.
I'm motion to adjourn.